Nukwang do Long Hongva. Dorma Sahneyah, I'm coming to you from the Hopi Nation in Arizona. In everyday life, security and justice for a woman depends largely on whether the local government has the authority to police, prosecute, and punish crimes, and to pass laws that criminalize violence perpetrated against women. In most non-Indian communities in the United States, county or city governments have, by and large, unquestionable authority to investigate and prosecute both misdemeanor and felony crimes committed against women. United States law has left tribal governments with inadequate legal authority to protect its citizens, allowing perpetrators to prey on Native women with impunity. Restrictions placed on the authority of tribal governments have created major systemic barriers that deny Indian women access to justice. Current U.S. law promotes a system of major legal barriers that obstruct the ability of Indian nations to protect the safety of Native women living within their territories. Some examples of such barriers include stripping tribal criminal jurisdiction and limiting sentencing authority of tribal courts. As a result of these legal barriers, criminal jurisdiction on Indian lands is currently divided among three governments: federal, tribal, and state. A determination of which government has jurisdiction often requires a complicated, confusing, and time-consuming analysis of several factors: location, type, and severity of the crime, Indian status of the perpetrator, and Indian status of the victim. The United States began asserting criminal jurisdiction on Indian lands in the 1800s. Congress has passed a series of statutes giving the federal government criminal authority over certain crimes. The Major Crimes Act authorizes federal jurisdiction over 15 crimes committed by Indians in Indian country, regardless of whether the victims are Indian or non-Indians. It can be said that the Major Crimes Act reflects a major intrusion by the federal government into the internal affairs of tribes, and that the federal government has not adequately fulfilled its obligations under the Act to investigate, prosecute, and punish felony-level crimes committed in Indian country. The United States Supreme Court in Oliphant versus Sequamish Tribe stripped tribal governments of inherent authority to criminally prosecute non-Indians. Thus, for the last 30 years, Indian nations have been denied the authority to prosecute and punish non-Indians who commit physical or sexual assault against Indian women on Indian lands, in spite of the fact that nationally 88% of all violent crimes against Indian women are committed by non-Indians. The major problem with the Oliphant decision is that while placing even more limitations on tribes, it failed to place corresponding responsibility on the United States government or state governments to prosecute non-Indians who commit misdemeanor offenses on Indian lands. And so, although the United States or state government, where the United States has delegated this authority to the state, has the authority to prosecute non-Indian offenders, these governments regularly fail to do so. According to a recent study, federal prosecutors failed to prosecute 62% of all criminal cases, 75% of all rape and sexual assault cases, and 72% of child sexual assault cases occurring in Native communities. United States law limits tribal sentencing authority over Indian perpetrators on their own lands. Under the Major Crimes Act, Indian nations have concurrent authority to prosecute crimes committed by Indians. However, the Indian Civil Rights Act limits the sentencing authority of tribal courts to 1 year in jail and or a $5,000 fine, even for crimes as serious as rape. Recently, the Tribal Law and Order Act amended the Indian Civil Rights Act to allow tribes to sentence Indian offenders up to 3 years in prison and to pay a fine of up to $15,000 or both. However, this enhanced sentencing authority can only be exercised when certain protections have been afforded to the accused. While this is a tremendous step forward for some Indian nations, the reality is that the reality is that many tribes do not have the resources to meet the TLOA requirements. It may take a significant amount of time before any tribes are able to take advantage of this enhanced sentencing authority, leaving in the meanwhile many Indian women without an adequate remedy. The inadequate response of the United States to the epidemic of violence against Indian women adversely impacts entire Native nations, which already suffer from the worst socioeconomic status of any population in the United States. United States laws have created a law enforcement void that appears to condone violence against Native women and permits perpetrators to act with impunity on Native lands. The United States has not used all the legal means at its disposal to combat the human rights violations occurring against Native women. Consequently, Native women and Native nations are left essentially defenseless to countless human rights violations. Guna'a, thank you.